In recent years, the issue of police misconduct has come to the forefront of public attention. In California, a new law passed on January 1, 2023, allows for the decertification of police officers for serious misconduct, such as sexual assault, perjury, and wrongfully killing civilians. This means that if an officer's certification is pulled, they can no longer work as law enforcement anywhere in the state. 20 California police officers facing decertification for serious misconduct. Photo by Kenny Eliason. On Unsplash. According to the latest public list reviewed by KTVU FOX 20 police officers across California currently face possible decertification unless they are cleared by investigations or win their appeals. The officers on the list worked for departments in Rohnert Park, Redwood City, Sonoma County, San Francisco, San Diego, Kern, San Bernadino counties, and Stockton. 6 of these officers worked in the Bay Area and are accused of impersonating federal agents, falsifying evidence, and possessing child pornography, among other charges. The Commission of Peace Officer Standards, or POST, is responsible for decertifying officers for serious misconduct. The POST Advisory Board now has the authority to recommend whether to strip an officer of his or her certification, basically a license to work in policing. There are currently 7 members on the board, made up of mostly political appointees from law enforcement, who decide whether to revoke or suspend an officer's certification. An officer could ultimately appeal in court. A temporary suspension can last up to 3 years, while officers convicted of a felony will be barred from working as a peace officer again in California. However, officers who are being investigated for misconduct and facing decertification still have the presumption of innocence. The decertification list is updated on a rolling basis. The post commissioners have a stack of cases, many dating back 3 years, to continue investigating. As a result, more officers may be added to the list in the future. While some police officers have been critical of the decertification process, Allison Berry Wilkinson, who represents many police officers, believes that the public list is a good thing. She says, "This does present some challenges. There is the presumption of innocence while they are being investigated whether their certification is suspended." Stuart Hanlon, who is representing a former Rohnert Park police officer, also believes that the public has a right to know. He says, "The understanding is that most cops do good things, but the bad ones shouldn't be police officers anymore. And we get to see now. So it's a transparency that's a long time coming." Arnold Threets, the chief of inspectors for the Contra Costa County District Attorney's Office, where Andrew Hall was prosecuted for killing Latimer Arboleda in 2018, says that decertifying officers and making their names public are in the public's interest. Threets adds that the secrecy only helps the person who has done something wrong. The public needs confidence in police. In conclusion, the new law allowing for the decertification of police officers for serious misconduct in California is an important step in holding law enforcement accountable for their actions. While some officers may view it as unfair, the public has a right to transparency and accountability. By making the decertification list public, it can help restore confidence in law enforcement and send a message that police misconduct will not be tolerated in California.